In this video, I'm going to try to stop you from losing thousands of pounds on a claim that is just never going to work, and how I might suggest you go about finding this out before you spend the money. So welcome back. I'm the Black Belt Barrister, helping you to understand law and helping you in your claims in this video. So more than once, we've had clients come to us having spent many thousands of pounds, in some cases over £40,000, running a claim against somebody else, only to come to us for specialist and very discreet advice on their case as to the merits of their case and whether they have a case at all and whether that case is likely to succeed. And in more than one of those cases, having spent more than £40,000, the advice has been that there is no case. The case simply will not succeed, and the money they've spent so far is probably wasted. And if they do run the case to court, they are likely to lose more money and likely to have to pay the costs of the other side. So how can you avoid this situation? Well, that's what I'm going to help you with, so you don't have to go through that and lose the money. So the obvious question that stares everybody in the face, and yet so few people actually ask, is, do I have a case in the first place? How would you know if you have a case? If it's a criminal case, how would you know if you have a defense? Unless, of course, you seek formal legal advice. Now, it's no secret that legal advice can be expensive. That's one of the reasons I set up this channel, to help more people understand the law so that you can have a good idea of whether you might have a case before you decide to go to a solicitor or a barrister to seek that advice formally. Obviously, this channel cannot be formal legal advice, but it can give you an idea as to when you might just have a case so that you can then go and spend a little bit of money to see whether you have a case or not. So what is it you need to know when you're talking to a lawyer to know whether you have a case or not? Well, it breaks down into a few different things. First of all, you need to know what the claim is in the first place. There has to be a basis of the claim in the first place. For example, if there's a company that has absolutely nothing to do with me and they have no relationship with me, I cannot claim some kind of negligence against them because I won't be able to establish any kind of duty of care. And without a duty of care, I cannot establish negligence because there won't be a breach of that duty of care, which is required for a negligence claim. One such example of this, which is a real case, is where someone had a chargeback to their business and they tried to sue the card issuer, which had no contractual relationship or relationship whatever with this person, for negligence, for failing to look at the full details of the case. Now, that claim was bound to fail from the beginning because there's no contractual relationship, there's no relationship at all. But this person had already spent a significant amount of money, but there was no case at all. So the first step is determining what the case is. It might be a breach of contract, it might be negligence, or anything else that you may not be aware of. But that's the first thing to determine, whether there is a basis for the claim. Next, you need to look at the strengths of your case. And those strengths might be simply the details of what happened. It might be the evidence that you have, which will be a strength for your case. It might be how badly the other side has behaved, which would make your case stronger as well. You want to know what these strengths are, but equally with the strengths, you also want to know what the weaknesses of your case are. If you are missing a key piece of evidence that without which your case is going to fail, you need to know right at the outset, even before you issue a claim, whether you have this kind of weakness in your case, because if you get to court and you don't have it, it could make the whole case collapse. And so within all of that, you need to know what it is that you need to prove. So starting with what the claim is and then what the strengths and weaknesses are, you will know what elements you need to prove to overcome your weaknesses, to reinforce your strengths, and to fulfill the elements of the claim in the first place. These are the questions you need to be asking your lawyer. And to do all of that, you look at all of the evidence that is available so that you can scour any documents and CCTV and chronology, witness evidence, whatever it might be, so that you can look at all of this evidence available so that you can determine what you are able to prove to overcome the weaknesses and to reinforce the strengths of your case. And finally, you need to look at whether there's any limitation issues. If you've had a contract which was more than 6 years ago, there's almost certainly no chance you're going to be able to bring a claim because contract claims are limited under the Limitation Act by 6 years. Various other limitations for other areas Personal injury is usually limited to 3 years unless it's a minor, and then it runs from the age of 18 or date from knowledge, and there's various other rules that append to injuries and things like that. But again, limitation is something that you need to ask your lawyer to specifically look at. Because again, we've come across cases where claims have been issued. We've been defending a claim where a claim has been issued, but it was way out of limitation. So there was no chance that claim was going to succeed at all. So obviously our response was to get the claim struck out on the basis that the limitation has run out. Next, you'll need to look at what the other side is saying, and you will only know this if you've written to them to ask them what they say about the claim and your complaint in the first place. This is what we call pre-action protocol. You go through these stages to try to determine what the other side are saying about the claim. They may agree to part of it, they may negotiate part of it, and there might be a relationship that you want to salvage with them. It might be a builder and you want them to finish the work, and so salvaging that relationship might be important. It might be a company that you have an ongoing business with, and therefore you want to salvage that relationship. You may be able to do that if you write to them to talk to them about your prospective claim, but it's far less likely if you've issued the claim already. And whilst doing all of this, don't forget to check your house insurance, because house insurance very often will cover legal expenses for claims such as these. Even if it's an expensive TV and the shop is refusing to repair or replace it, your house insurance may cover a claim against them, usually up to £100,000 in costs, where it does cover your legal expenses. So make sure you check that. So no doubt there'll be lots more questions coming out of this, so please drop them in the comments box below. Share this with somebody that you know is going through a difficult time at the moment with some kind of dispute. Please drop the video a like, and as always, thanks for watching.